All right, now we're live again, and we're discussing some changes to HS 127, and those changes will be reflected in draft 5.1, which we should have shortly. I think we're clear. I think we've reached very amicable.
I'm sorry, that's
Yeah, he's trying to fix themselves.
Yes, Ben. Did you raise your hand or were you just giving up?
Yeah.
giving up on that one though, volume, please, but we're good.
I see you on the TV and I
Sorry.
forgot you were live. All right, hopefully this will be a comedy sketch on Saturday Night Live.
I guess we probably can't do the cabaret this year, but.
Okay, so I have incorporated the changes as far as just limiting the objection to subject matter jurisdiction and replacing the review of the length of interruption or revocation and changing that to may be a consideration. Any other changes that the committee would like to see?
No.
Okay, so I will then put the newest version on the screen.
I have a question. I'm sorry.
Yeah, Matt.
Because this is coming up more and more lately, as especially the last couple of years, the legislature passes something, changes something, passes something, changes it again. On the effect of passage, it says shall take effect on passage. What is the intent of the legislature on the application of this to cases that are already in the pipeline?
I mean, I believe that there is current statute that this would not affect current cases. It would just be forward-looking.
Yeah, well, courts have been very split on that issue, and I agree with you. It's Title 1 VSA 214, which does that, but courts don't always see it the same way. And if I would appreciate it if the committee could do something to clarify the retroactive or not application of this bill.
That would be
Yes.
for all cases filed prospectively after the date of passage. That what you're asking?
No, he wants everything that's in the pipeline now to be covered.
Okay.
Prospective only.
No, he wants it to be,
Matt wants it to
Maybe
be
in the
all
pipeline to
cases
be
in the
covered.
pipeline.
Oh, I see.
yeah,
I
not
thought he just
prospect.
wanted clarity.
Well, he does want clarity, but he wants it for cases
Okay.
in the pipeline.
Whatever Matt wants.
Just so the committee's edification, Judge Mello was before us on judicial retention, and he was stationed in Washington County where all these were being filed. And he did make note that all of a sudden there was an avalanche of cases that they were under. And so got a lot of things in the pipeline that could probably benefit from us allowing this to cover those cases.
I remind you that the other body, if this is successful, will have a good hard look at this, I'm sure.
Yeah.
No kidding.
So what do we want to do?
But not that I don't want to get it correct, but
I think we should make it all the cases that are currently have been filed as
of the date of passage.
okay, why don't we go,
As of the,
why don't
yeah.
we go over the
Yeah.
redraft shortly?
How's that work? Is that an instruction for Ben? All cases as of the date filed, as of the date of passage, will be included, nothing else.
Yeah.
Yeah, I could include an intent section that wouldn't necessarily become law, but would be instructive to say that this includes would apply to all current cases within the court system and all to be filed.
All right,
And then as far as the changes that were discussed previously, on lines 3 and 4 on page 2, it now reads that the department shall file an objection to subject matter jurisdiction within 14 days, which shall stay the filing of the record on appeal until the court issues an order on the department's objection. Clarify that the objection is only concerning the subject matter jurisdiction. And then in subdivision 2, lines 13 through 15 now makes it the discretion, the length of interruption or revocation may be consideration in the use of discretion determination. And then as far as the remaining changes to this draft from draft 3.1 and 4.1, now they're on 5.1, in subsection D or subdivision 2, subsection D on line 6, this goes back to the use of discretion standard that's currently within statute, that it shall be an abuse of the department's discretion to revoke furlough or interrupt furlough status for 180 days or longer for a technical violation unless one of the enumerated exceptions. So that is the extent of the changes of the previous two drafts.
All right.
Can I just ask why we went to 180 days? What was the rationale for that?
Because it takes 6 months generally for the case to be heard. And that's also, so if somebody had a 160 day, I don't know if they do it, but if they have a 6 month interrupt, by the time the case is heard, they've already served the 6 months. Matt?
I just want to make sure regarding this retroactive application thing is that the people who have filed based on a 90-day interrupt are still going to get their day in court consistent with that, as opposed to in the middle of the, in the middle of the litigation, changing it to 180 days. Because that was what they had filed in anticipation of.
Here's what I'm going to suggest is we can continue this discussion next week. If we vote the bill out, we can get this legislative intent and how we want to do it as an amendment before third reading. So if we vote the bill out today, it'll get to the floor. It'll be not on the floor until Wednesday at the earliest.
Thursday.
No, Thursday.
Thursday.
So a week from now, we can find some time on to fix this at our meeting on Tuesday. So give everybody the weekend to look at this, and next Monday, and then do, if there are changes we need to do, we can do them on the floor. I think we're all agreed on what we're trying to accomplish here. So in the interest of the final day.
Okay, I think everybody is sitting
Yeah,
there
I think
hearing this.
I
and all file
appreciate
like
Matt and
right now, everybody in the whole prison is
I
gonna file right
appreciate
now.
all the parties having worked hard together to come to some kind of an agreement here. So.
Call Judge Mello.
Pardon?
Better call Judge Mello to get ready, because everybody's hearing any of this, even if they don't have any kind of a case.
Well, this is gonna be the Judge Mello case production. So, did everybody hear that conclusion? Ben is gonna draft it up. We will put it on the calendar. It won't be dealt with till next Thursday. It gives us time on on Wednesday morning to briefly go over it. And if there's any questions or if it's not clear about the retroactivity piece, we can clear it up then with an amendment before third reading. Is that fair, everybody?
Yes.
So gives you time to think about how we want to accomplish. I think we're all want to accomplish the same thing, Matt. So it's just making sure that it's written the way that will work. So rather than trying to do it on the fly.
Yeah, I'll work on it. If anything, I can consult with Attorney General.
So we'll just schedule 15 minutes Tuesday morning for this to amendments to S-127. If any. All right. Is this draft 5.1?
Yes.
All right, I would accept the motion to report favorably draft 5.1 of S-127. Or the amendment, draft 5.1. Amend the bill. Senator Ruth has moved. Peggy, would you please call the roll? Oh, is there any discussion? Hearing none, Peggy, would you please call the roll?
Senator Benning?
Yes.
Senator Nika?
Yes,
Senator White?
Yes.
Senator Pruitt?
Yes.
Senator Sears?
Yes. All right. So is there a motion to report the bill favorably as amended?
sure.
Senator White has moved that we report, Senator Nika moved that we report the bill favorably as amended. Is there any further discussion? Hearing none. Peggy, would you please call the roll?
Senator Benning?
Yes.
Senator Nika?
Yes,
Senator White? Yes. Senator Pruitt?
Yes.
Senator Sears?
Yes. I'm happy to report this bill.
Good, because
We're happy to have you.
we are very happy to have you report, so.
Oh, I actually understand the concept. Well, the concept was to reduce the furlough interrupts.
right.
Yeah.
It's gonna be a huge block of it. Right.
That's gonna be a big block, so.
Okay.
We're
So,
adjourning at 10:45, right?
huh?
We're adjourning at 10:45.
Well, I hope so, but we're gonna try to take up S-254. We're gonna break at 10.
Oh,
Oh, I'm sorry.
Oh, no.
And then we'll come back. So we're gonna switch hats to S-254. Qualified immunity. Oh, boy, she said.
Yeah.
Well, it's fun, I'll be back in the same room.
it is. I
Well,
have missed. And,
So
oh,
what I'm gonna do is
I love it. Oh my God.
I'm gonna take the easy way out.
Here, it's beautiful.
And
Look at that.
then if you, we have, you should have in your file, qualified immunity, a redraft.
Yes.
Dated 3/10 at 9:51 a.m.
Nice.
Okay, is that
Wait, this one's at 8:30.
8:30?
Yeah, so there's draft 3.1, which I just submitted this morning,
Okay.
but there's also draft.
I'm sorry. Yep, all right. I'm gonna, before Ben puts this up, I'd like to explain what I'm trying to do. It's become clear to me that with the amount of time that we have, and given the efforts the last few years to improve fair and impartial policing policies, broad use of force and guidelines, improve police officer training, universal body cameras. I still support the idea of the elimination of qualified immunity, but it's clear to me that to try to do that this year is next to impossible. Given the length of time we've had in committee, even though we've had extensive discussion. Some say that we're, what I've heard is the way we do it now has worked well. And suits settled by the various departments in this state. We don't have good information about those, but we do know that There have been a lot of settlements. It's a controversial subject, and I believe we need to get it right. And as a citizen legislature, we deal with a lot of different issues, just like the one just previously. On this end, I think we need to get beyond the back and forth of the lawyers from each side by commissioning an independent report on the state of Vermont qualified immunity law and how it's working now. I don't think we have to have a study. But what I really am lacking is when I hear from one side, oh no, they do have it. It's like my argument with my town manager in Bennington. Well, they already have access to suit. Look at all the settlements we've had. Well, yeah, but what about the other cases? And so I hear from the other side. So I've been working with Ben to try to craft something. The other thing I heard was there is some doubt about Zulu and whether it covers municipal police and covers sheriffs. We know it covers state troopers. That was clear. So what this attempts to do, a draft 3.1 attempts to do, is say it's our intent that Zulu covers all municipal and all law enforcement in the state, so that the current state of affairs is not questioned. We can argue about the decision, we will. And it also contains, it's not a study, but a report. And Ben can go over the report that he and I have looked at. It's a report on the access to justice and qualified immunity. And we're hopeful that he would get assistance from various groups that have been here on both sides, as well as it looks like a project that might be right for the Center for Justice Reform at the Vermont Law School. So this, I think, I realize that the proponents of the bill will not be happy. I realize that the opponents may not be completely happy that the issue is still out there. But for me anyway, we need to understand does Vermont have a problem? We looked at no knock warrants. And this committee determined that it was not necessary to change that law based upon the testimony. It was clear from both sides. This one hasn't been that way, and I'd like to get some clarity. And if we don't have a problem, then we don't need to change it. But if we do have a problem, as I suspect we do, then I'd like a little bit of a better basis. And I really want to thank Ben, who has been over backwards with me on this issue and done some tremendous work. I don't know where we'd be without Ben, listening to both sides, but this is what we've come up with. So I'll let Ben read it over, then we'll take a break at 10, come back and talk a little bit about it for about a half an hour and see if there's something that the committee can buy into.
Share my screen.
While you're bringing it up, can I make a
Yeah.
suggestion on lines 14 and 15, where it says against any Vermont state, county, or municipal law enforcement officer? I think it should be all certified law enforcement officers, because they're, like UVM has its own its own agency, and so this wouldn't cover.
Yeah.
It should be all certified law enforcement officers in the state, regardless of who they.
Are UVM officers certified?
Oh, yes, absolutely.
You should see what they have in their trunks. I walked by one of the UVM police cars with the trunk open, and it was like an arsenal.
What's that, right?
There's a lot of riot kind of stuff in there.
Yeah.
He was just bringing that to donate to Ukraine's efforts.
But anyway, just so that it makes sure that, and there might be one or two other kind of quasi,
Constables and
well, yeah, and any certified law enforcement officer, yeah, just a suggestion.
Good idea.
Start hiring them, so.
So go ahead, Ben.
No, they can't.
So this is, so Ben Obergrosky for the Office of Legislative Counsel. We're looking at draft 3.1 of the strike all amendment to S-254. This is almost completely new compared to the last version. It still creates under section 1 a new chapter 190 under title 12. This is now termed though violations of Article 11 of the Vermont Constitution by law enforcement. It creates a new section 5607 entitled Standard to Recover Damages. And subsection A is essentially intended to codify the Zulo standard. And as Senator White said, to make sure it applies to all Vermont certified law enforcement officers for violations of Article 11 of the Constitution of the state of Vermont. And that is the search and seizure provision. So this would cover roadside stops, anything seized during those stops, trying to arrest of individuals. So any potential violations that would come out of those types of interactions. And again, this is just to make it clear that this is the standard and it was espoused in Zulo, and to make it uniform across the board for all law enforcement officers for Article 11 violations, which again is what the Zulo, the holding in Zulo concern was an Article 11 violation. It does say that the common law under subsection B, the common law defense of qualified immunity shall not be a bar to any action seeking damages brought against a law enforcement officer for a violation of Article 11. And that's because under Zulo, it's a burden that the plaintiff must prove to obtain damages, and a limiting analysis that the court undertakes. So it's just to make sure that it's in concert and that qualified immunity is not a bar to that new burden that the plaintiff must prove under Zulo.
Can I just stop you? That line, correct me if I'm wrong, but my memory says that line is taken exactly from the Zulo case.
I can't recall at the moment if it's a direct quote. And you're talking about subsection B. Yeah. But my intent was to capture it as closely as possible. And really just to reference
I
it.
just want to, this is a good place to say this. When the bill began, it was creating a new right of action, expanding what Zulo had already put in place to cover all certified law enforcement officers, as opposed to just state police troopers. That is what I understand now is the intent of the bill.
Correct.
Yeah, brilliant move on your part. Just so you know. Thank you.
No, it is. It's a good, because I think there was, anyway, I won't go there.
And moving on to what would now be new section 5608. This is a record of case disposition. This was the old section 5610 of version 2.1, and this is the one where all judgments and settlements that an agency would pay must be maintained, which would include a copy of the underlying complaint, and it would be subject to public disclosure unless an exemption under the Public Records Act applied. But any record that would be disclosed would include the name of the law enforcement agency and any monetary amount paid under the judgment or settlement. And then there's language that would ensure that all personally identifiable information contained in judgment or settlement shall be redacted prior to disclosure. And this is an effort to make sure to really track what's going on in Vermont with law enforcement agencies and these claims, and also to ensure that people that are included in the cases, their information isn't unnecessarily disclosed.
So that's a question too. So
Yeah.
does the officer's name, is the officer's name disclosed?
It would be all personally identifiable information. That would be, so the officer's name would be included within that, so it would not be disclosed. That's the intent of this.
Oh, the officer's name would not be
Right?
disclosed,
It's just
as well as the person.
Well, you read in the paper that there was a settlement reached, for example, with former Representative Morris and her family.
Yeah.
And it tells us the amount,
Yeah.
but many of these settlements
Or privately.
are privately, and we don't know they exist. And people are saying, well, yes, they are already getting settlements, they already have access to justice. Well, how many of them are there? This will just give
Yeah.
people the ability, without divulging the name of the officer or
The
the
name of the person suing.
name of the person. In the case of former Representative Morris and her family, that was made public like that.
And then it, even though everything is redacted,
Yeah, people know.
if people know if there's a suit against the Brattleboro Police Department, you know, but I think this is good, the
Yeah.
way this is written.
Yeah.
And then,
What I'm interested in, and hopefully the committee is what is the current status? So how many of them are there? And we got such conflicting information from both sides on this.
moving on to section 2, this is the report that Senator Sears discussed, and it's the report on access to civil justice remedies and law enforcement qualified immunity in Vermont. What this does is essentially the Office of Legislative Counsel by November 15th of this year would produce a report to the Senate Committee on Judiciary, the House Committee on Judiciary, and the Joint Legislative Justice Oversight Committee concerning the impact of the doctrine of qualified immunity on access to civil justice remedies for people wrongfully harmed by bad faith policing and violations of civil rights in the state of Vermont. In particular, the report shall identify 1, the origins of the doctrine of qualified immunity and its present interpretation by the state courts of Vermont. 2, existing constitutional, statutory, and common law causes of action for addressing the alleged misconduct of Vermont law enforcement under Vermont law. 3, existing immunities from suit concerning allegations of Vermont law enforcement misconduct under Vermont law. Existing defenses to liability concerning allegations of Vermont law enforcement misconduct under Vermont law. Existing statutory and common law limitations on damages. And the applicability of the doctrine of qualified immunity to Vermont state level law enforcement officers, county level law enforcement officers, and municipal law enforcement officers.
Just on that last number 6. So on page 1, or I'm sorry, on page 2, no, page 1 at the bottom, subsection B, we're removing qualified immunity in violations of Article 11. So is number 6 in the report meant to talk about what remains for applicability?
Essentially, yes, because that would just be for, in the previous section for Article 11 violations,
Yeah.
but it can apply in other situations. And I think the intent behind this is to give the committee, all the committees that would receive the report, the fullest picture possible of what the state of the law is in Vermont, just to analyze and see if there's any action to be had going forward.
Because it could be clarified to say the applicability of the doctrine exclusive of violations of Article 11. But I understand that's what you mean.
And to your point, Senator White, from before, I can change this to just say all certified law enforcement officers in the state. And then subsection B would that the Office of Legislative Counsel should have the administrative, technical, and legal assistance of the Attorney General's office, the Defender General's office, the Center of Justice Reform at BLS, and any other stakeholders interested in assisting with the report.
There's something to be said about a compromise that everybody hates and everybody loves. You know,
Well, it's been one of the most difficult bills. I was explaining to a reporter yesterday. Well, I think of the 3 that some of the more difficult bills that I've dealt with, one was civil unions, the chair of this committee. And the Supreme Court has said we had to act. So we didn't have a choice really. The other was Act 60, which was the decision, I can't remember her name. Little girl from a town in Addison County. But anyway, that was another, the Supreme Court said you had to act. In this case, nobody said you had to act. And it's been difficult because of the very emotional and honest disagreements on both sides. I remain in awe and deep respect of the folks from ACLU, Jay Diaz, the folks from the BIPOC community who have spoken out clearly in favor. I also, have a great deal of respect for Commissioner Sherling and other members of the Department of Public Safety, Matt Birmingham, and the state troopers. So I'm hopeful that this will at least allow Vermont to look at this in a different light, but also make sure that it's clear. I suspect that the Supreme Court would, if their case came up, but to make it clear that Zulu applies to all law enforcement in the state. So, well, I'm happy to hear from folks in a few minutes, but not to be brief because we basically have a half an hour to deal with it. We'll get back here at 10:15.